Okay, so welcome to today's Community Legal Centres Queensland webinar. My name's Carly Hanson and I'm one of the capacity building leads here at Community Legal Centres Queensland. You're joining us today for our session with Maurice Blackburn on assisting clients experiencing mortgage stress amidst rising interest rates. But first, I'd like to acknowledge that we're meeting today on the traditional lands of the Turrbal and the Yagara people here in Meanjin, Brisbane. So I wish to pay my deepest respects to elders past, present and future, and acknowledge that we're on stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to any traditional owners throughout the country and extend a very warm welcome to any First Nations people who are joining in today. So I'm really pleased today to welcome Josh Menon, Principal Lawyer and National Litigation Leader at Maurice Blackburn, who will be presenting the session this morning. By way of introduction, Josh is going to talk about the problem of rising interest rates amidst soaring property growth, generous tax incentives for property investors and record low interest rates previously, and that has resulted essentially in Australian households being amongst the most indebted in the world. So with the current interest rate rises, we will see thousands of people tipped over from fixed to variable rates, and there'll be some issues there potentially for people. So Josh will take us through the borrower's rights under the National Consumer Credit Protection Act 2009 and look at some of the pros and cons of taking a complaint to the Australian Financial Complaints Authority, AFCA, as opposed to litigating. So I'll let Josh tell you a little bit more about himself when I hand over in a moment. But firstly, I'd just like to do some quick housekeeping. So today's webinar is being recorded and we'll have the recording available this afternoon for you. The PowerPoints have been emailed out this morning and are also available to download from our website. And if you haven't grabbed them yet, you can download them from the handout section of the GoToWebinar control panel. We certainly encourage you to ask questions, so please type your question into the question box on the GoToWebinar control panel and I'll read your question out. You can also unmute yourself or put your hand up and I can unmute you so you can ask a question verbally if you wish. We will hold questions just until the end of the presentation, but feel free to type them in as you think of them. So I might now, without further ado, hand over to Josh to commence today's session. Thanks so much, Josh. I'll speak to you at the end of it.
Thank you so much, Carly. It's a pleasure to be here and thank you for inviting me back to talk about this important topic. I would also like to start by acknowledging the traditional owners of the lands that we're variously meeting on and paying respects to elders past, present and emerging. In my case, I'm coming to you from Ugamba country and I would also like to pledge my ongoing support for truth-telling and treaty for a people whose sovereignty was never ceded. We have a slide deck which has been made available and I'm going to talk through that deck. There's a bit to this topic and I understand from my own experience volunteering at Caxton that this is an issue that comes up a lot. Sometimes it's a hidden issue and it may be secondary to other financial stress related problems. It is an important issue for the, and I think now probably more than ever, at least in the last 20 years, I think household mortgage stress, I haven't seen it more serious than it is at the moment, and it's quite possibly getting worse. We're going to talk through some statistics on that and talk through the consumer protections that are in place, which are an important part of a consumer lawyer's toolkit. So let's get into the substance then. We've already had the contextual introduction, so I won't read through this, but it is just really important to note that there have been in the last couple of years an extraordinary increase in interest rates. supposedly to combat inflation coming out of the COVID pandemic, and it's causing a lot of pain and creating a lot of defaults, particularly as this enormous cohort of Australian borrowers transitions from fixed rate mortgages into variable rate mortgages. And so we'll now have a look through some of the history just to further give us some further context as to how we got here. So at the top, commissions, I'm not talking about the Royal Commission there, I'm talking about bonuses and commission payments which are made to mortgage brokers, banking staff, potentially, and anyone who is in the business of facilitating the writing of loans. Commissions are kind of the root of all evil when it comes to financial misconduct or unlawful conduct within financial institutions, based on my experience in various different types of disputes. And so I think it's fair to say that a lot of the problems do start there, because when you have commission incentives to write loans, in this instance, then a lot of loans get waved through and get the green light when additional scrutiny really should have been applied. So what are the other drivers for the problems that are now manifesting? Well, we've had a history of banks issuing interest-only loans, so loans where only the interest on the principal is repayable for a period of time, but that period of time inevitably expires. It might be after 3 years, might be after 5 years, and then that results in an obligation to pay off not only the interest but also the principal, and that can tip people into financial hardship and has done in many instances. Tax incentives such as negative gearing, which has long been a political hot potato, and no major political party has yet been determined enough to tackle it significantly. So those tax incentives remain, which means that all of the carrots are still there for people to invest in the market, which inflates prices and so forth. Benchmarking tools such as the household expenditure measure, or the HEM, and we're going to talk quite a bit about the HEM. These are tools used by lenders in order to determine a potential borrower's expenses without actually having to look line by line at their actual expenses. So it's effectively a pigeonholing exercise where, based on a borrower's demographics, the size of the household, their age and so forth, their expenses is a number generated by a program that was written by, I think it was the University of Melbourne. And this has been the way in which lenders for many years now have, in the most part, determined people's the affordability for borrowing based on people's expenditure. And of course, it's unreliable in many instances, and we'll talk about that. And also what the industry has called liar loans is not a term that I care for, but it is where loan applications are made which include inaccurate or false information about the borrower's financial circumstances. And it's not always the borrower's fault. It has been quite often the fault of a lending intermediary, such as a mortgage broker, who again is incentivized by commissions to push loans through. These all sort of culminated in a perfect storm, which was a major driver that led to the 2017 Financial Services Royal Commission, which was presided over by Commissioner Hayne. And the outcome of the Royal Commission in relation to mortgage stress and household lending was a recommendation to ban broker commissions. We'll talk about what happened with that recommendation, and also the best interests duty to be imposed on brokers. Running parallel to the Royal Commission was a case of ASIC and Westpac, where ASIC was challenging Westpac's use of the household expenditure measure benchmarking tool, and we'll talk about the outcome of that. And then the regulator applied prudential tightening, which restricted interest-only loans to 30% of new mortgages and imposed a 2.5% buffer that banks have to apply when looking at whether somebody can service a loan. So they have to not only look at the interest rate at the current time and serviceability on that interest rate, but also serviceability on that interest rate plus 2.5%. So that's a bit of historical context. Let's fast forward to 2024 and talk about fixed rate mortgages ending in mortgage stress for many borrowers. So we've seen the cash rate jump from a record low of 0.1% in May 2022 to 4.35% as at April 2024. We haven't seen an increase for several months, which is positive. However, the RBA certainly hasn't ruled out further increases under the cover of continuing to seek to combat inflation. The RBA has expected more than 800,000 households would fall off fixed rates onto more expensive variable rates in 2023. Roughly 1 in 4 home borrowers who took out mortgages at fixed rates of around 2% come off them and onto variable rates of 6 to 9%. So it's a really very substantial jump, and I'm sure there's many on the call who have felt that personally, but also many on the call who will have seen clients who have felt that and are now struggling with cost of living as a consequence. For households with an average mortgage of $600,000, that's an increase of $2,200 per month to around $4,000. And Westpac has warned that almost half of its $471 billion in home loans were written using interest rate buffers that are set to be exceeded. So the 2.5 buffer clearly not enough to match the increase from almost zero cash rate to 4.35. And what are investors doing? Because as we know, there's a lot of tax incentives to invest in real estate, and so there's huge numbers of investors who own investment properties that they rent out. They're passing it on to the renters, and so there we've seen enormous rent increases calculated to top 10%, which did in fact top 10% in 2022 and 2023. And the last time we saw a rental increase trend of this type was in the GFC, which was back in 2007. There's a number of other factors which are exacerbating this problem, which you probably are familiar with from the usual news cycle, and that's the shortage of building materials and slowing down in construction. So there's a sort of a supply problem which the current Labor government's seeking to address in collaboration with the capital held in industry funds in particular, but that's a slow burn and will take a long time before it actually creates dwellings that people can live with in order to take off pressure in rent. There's a lack of affordable and social housing, increasing numbers of short-term rentals, recent high income growth for some, the trend towards smaller households. So that fewer people living in households means more households needed, and a fresh surge in migration. And there's a report by property data firm PropTrack, which shows rental vacancy rates have fallen, with the share of rental properties on the market now 54% lower compared to pre-pandemic levels. Now, I've thrown this in here. I'm not an economist, so you can take what I say here with a grain of salt if you want to, but I think it is worth just noting that this narrative that we constantly receive, which is that interest rates have gone up in order to combat inflation, is often associated with that narrative is this suggestion that it's it's the middle class that and ordinary income earners that are driving the inflation because of increases in household wealth and wages. This graph, I think, is pretty powerful in suggesting otherwise, that actually wages have gone up very little over the past 25 years relative to corporate profits, which have skyrocketed, particularly in the last 10 years. So I think it is important to bear that in mind when you consider, well, why is the economy overheating and causing inflation? Where is that money coming from? We'll have a look at the corporate profits that are being generated, and then you can get into another discussion about whether or not those corporates are paying their fair share of tax, which I take the view that they certainly are not. But that's a topic for a different day. I also think it's worth noting that during the COVID pandemic, the Morrison government allowed people to access $20,000 from their superannuation account balances on a tax-free basis, which resulted in the release of $38 billion from Australian workers' superannuation funds, which then went back into the economy. Which I haven't heard any economists note that that is a driver of inflation, but I would suggest that it must have been. So that's a lot of context. Let's move on and talk about the statutory protections that have been created. So why do we have this? After the global financial crisis back in 2007, 2008, the National Consumer Credit Protection Act, the NCCP Act, which incorporated the National Credit Code, they were put in place, and they were put in place in order to provide consumer protections, encourage prudent lending practices, and curtail undesirable market practices by lenders and intermediaries. That last point's important because that was one of the big learnings from the global financial crisis, which was caused essentially by predatory lending practices in the United States, where unaffordable home loans were doled out to consumers who weren't in a position to determine that those home loans would balloon out and become unsustainable. The debt, mortgages themselves were repackaged as financial products and sold on to various banking institutions around the world, and it has essentially infected the global economic system, such that when there was a mass default on those home loans, it was felt all around the world. So this was a very important piece of legislation put in place to address that, so that Australia hopefully wouldn't have a similar experience. It's intended to ensure that credit providers conduct appropriate inquiries of the consumer to ensure that the credit is provided responsibly, and enhance consumer protection by ensuring that credit providers did not provide credit to consumers who do not have the capacity to repay, or where it is otherwise unsuitable. So let's have a look at the key sections that I think are important to have front of mind. 128, that provides that the licensee, that is the bank or the intermediary, it might be a broker, must not enter into a credit contract with a consumer unless it has, within 90 days of entering into the contract, made an assessment as to whether the contract will be unsuitable for the consumer, made reasonable inquiries about the consumer's requirements and objectives in relation to the credit contract. So they have to actually make inquiries about the requirements and objective. Why is the loan being taken? What is it that their funds are intended to achieve? Make reasonable inquiries about the consumer's financial situation, but not only make inquiries, but also take reasonable steps to verify the consumer's financial situation. And that's where we'll get into the discussion about the bank's conduct in using benchmarking tools like the HEM. Section 131 provides that the licensee must assess the credit contract as unsuitable for the consumer if at the time of assessment it is likely that the consumer will be unable to comply with their financial obligations under the contract or could comply with those obligations only with substantial hardship, or the contract will not meet the consumer's requirements or objectives. And pursuant to 131 subsection 3, it's presumed that the consumer will be under substantial hardship if they can only comply with the financial obligations under the contract by selling their principal place of residence. Section 132, consumers are entitled to copies of the assessment before and after entering into the credit contract. So this is an important one. Banks have to hand over their assessment, which has been conducted under the previous section that we discussed. And it's always a good idea to request that from the bank early if you get a sense that there's been irresponsible lending. A lender is prohibited from entering into an unsuitable contract with a consumer. The fact that a mortgage broker has made a preliminary assessment in relation to a consumer does not relieve the lender of its obligation to make its own assessment, okay? And this position has been confirmed in the cases that I've cited there, where the lender's reliance on the broker's assessment was not sufficient. Section 178, we're talking now about the remedies provided under the NCCP Act and also the time limits. So the court may order the defendant to compensate the plaintiff for loss or damages suffered by the plaintiff if the defendant has contravened a civil penalty provision or committed an offence against the NCCP Act. Okay, so this would occur in the event that the sections that we've just discussed were contravened, and the loss or damage resulted from contravention or commission of the offence. So where there's a breach and where losses flow from that breach. Importantly, we're talking about the court. We're not talking about AFCA. The legislation is specific in using the language the court. The court may only make an order for compensation pursuant to section 178 if the plaintiff applies within 6 years of the day the cause of action that relates to the contravention or commission of the offence accrued. So there's an important time limitation built in here. So we don't go, for these types of cases through the courts, we don't go to the limitation of actions statute in the relevant state. We find the statute of limitations provision in the NCCP Act itself. So within 6 years of the day the cause of action relates to the contravention or commission of the offence accrued. So what is that date? Is it the date that the loan is written? In which case a lot of people might be out of time by the time they suffer losses and seek to bring an action. We dug a little bit deeper to try to get to the bottom of that potential problem, and in the explanatory memorandum at 4.85, it says the compensation orders may only be made within 6 years of the day of the cause of action, that is the loss or damage to the consumer. Okay, so if anybody challenges you on statute of limitations, you can make the argument that based on the explanatory memorandum, the relevant cause of action arises when the loss or damage is suffered by the consumer that relates to the contravention of an offence or offence accrued. And this is to capture the situation where the contravention, for example, putting a consumer in an unsuitable contract, does not result in loss or damage to the consumer until a later time. What about AFCA time limits? Because probably most of you in your practices would be going to AFCA rather than moving straight to litigation, which is understandable because AFCA is a costs neutral jurisdiction in large part. And so it's essentially a way of sort of getting a free kick and trying to hold the lender to account without exposing a consumer to adverse costs if they're unsuccessful in their court case. So AFCA time limits, well, it depends on what type of action is being brought. B.4.2.1 of the AFCA rules says that where a complaint relates to a variation of a credit contract as a result of financial hardship, an unjust transaction or unconscionable interest, and other charges under the National Credit Code, AFCA will generally not consider the complaint unless it was submitted to AFCA before the later of the following: 2 years of the date when the credit contract is rescinded, or where prior to lodging a complaint with AFCA, the complainant was given an IDR response in relation to the complaint from the financial firm within 2 years from the date of the IDR response. So that's actually a pretty generous time limit, because it's the later of those two. So even if the contract was rescinded more than 2 years before the application was brought in AFCA, by lodging a complaint, an internal dispute resolution complaint with the lender or the broker, and then getting a response to that complaint, that can trigger a new 2-year period within which an AFCA complaint can be brought. So that's handy to know. But that's principally for variation of a credit contract. So hopefully there'll be people on the call who have some experience with hardship variation requests, which can be made. That's not necessarily an allegation that there's been irresponsible lending. It might just be a request that can be made to the bank under these same statutes, that the loan is unaffordable because perhaps somebody's circumstances have changed. They might have lost their job, and they are seeking a hardship variation, which might be the forgiveness of debt for a period of time, or the freezing of the debt repayments for a period of time while somebody gets back on their feet. And these time limitation provisions would apply there. For all other complaints that don't fall within that B.4.2.1, AFCA will generally not consider a complaint unless it was submitted to AFCA before the earlier of the following time limits. So it's important there they use the word earlier. Within 6 years of when the complainant first became aware that they suffered the loss. So that's a subjective and an objective test. When the complainant first becomes aware or should reasonably have become aware. And it's the earlier of that, or where prior to submitting the complaint to AFCA, there was an IDR response, and it's 2 years from the IDR response. So now let's move on and talk about losses and what can be claimed in compensation through AFCA versus through litigation. And then I'm going to run through a case study of a case that my firm ran through AFCA, and then took to litigation and compare the differences in outcome. So can losses include investment loss on the property? This is the big question. It hasn't materialized as a hugely widespread question, because we have continued to see the steady and in some instances sharp increase in property values as a generalization nationally. And for that reason, the question of capital losses is not often a huge issue, because when somebody is forced to sell their property, there's a reasonable chance that it will have appreciated in value rather than depreciated. However, that's certainly not the case in all instances, and there are pockets, particularly where there's been mining busts in central Queensland, for example, but also in Western Australia in a big way, which have caused property price declines. It's also an issue in flood and disaster-prone areas. So where there is a capital loss, and you ask AFCA to compensate you for that capital loss where it finds that there's been irresponsible lending, AFCA has made it very clear that it will not agree to do so. It says that the consumer bears the risk of their investment choice, which may either increase or decrease in value over time. in those cases, the consumer's loss is only the interest and fees they have paid to the financial services provider. And then more recently, it's said, because it's published a practice note on this, on irresponsible lending, and it's more recently, and it said AFCA generally considers a complainant received a benefit from the full amount of credit used to purchase a residential investment property, even if they suffer a capital loss on resale of that property. But I want to point out that there is, in my view, an inconsistency in AFCA's approach here, with all due respect to AFCA, because AFCA do reduce damages by investment gains, and that would include rental income and crystallised capital gains. And I'll demonstrate that by looking at the way in which AFCA calculate losses. So the AFCA approach to responsible lending, practice note, which is linked at the bottom of the slide here, says that AFCA will generally require a financial firm to compensate a complainant for their net loss. So just to be clear, this is after they've determined that there's a breach of the statute. So they've found that there's that they've breached their liability. The next question is, do losses flow from that liability? And if so, what are those losses? In calculating them, they generally require a firm to compensate a complainant for their net loss. The complainant's net loss is their gross loss, less the benefit that they receive from the credit contract. And here we see, this is taken from AFCA's material. What is gross loss? Amounts paid to the financial firm under the credit contract, for example, repayments and fees, outstanding liability under a credit contract, amounts paid to third parties related to a credit contract. And so you calculate that, and then you take from that the benefits received, and that would include the amount of credit, but also importantly, other benefits received from the use of the credit, for example, rental income. Okay, fair enough. Crystallized capital gains. Okay, so where there has been a crystallized capital gain, AFCA will deduct that from the losses. But as we've noted, where there has been a crystallized capital loss, they won't pay that as compensation. They won't order that that be paid as compensation. Okay, so next, when complainants do not receive a benefit from the loan, again, this is from AFCA's material, in some cases, AFCA may determine the complainant's benefit from the credit contract is less than the amount of credit the lender provided them, and the complainant received no benefit from the credit contract. Examples would include the funds were applied for the benefit of or misappropriated by a third party, or there was a secured loan to purchase a personal asset that the complainant now agrees to surrender or sell, and that asset has declined in value, so the complainant has suffered a capital loss. So it's that one about misappropriation that I suppose I want to focus on, because it's often the case, unfortunately, that people apply for large mortgages, and when they obtain those funds, they don't actually use it for the stated purpose. And it's not to suggest that they made the loan under false pretenses. It might be that after receiving the funds or after making their application, they are the victim of a scam. And I've seen this happen, for example, where a client of mine applied for additional credit on her mortgage in order to conduct renovations, obtained those funds, but unfortunately was conned into purchasing art from a scammer who was operating out of South Africa, and transferred those funds overseas and never to be seen again. And in that case, we were able to point to some red flags that the bank should have been aware of, that these funds were actually headed offshore, and made the allegation that they failed to adequately intervene. So just to finish on this slide though, where loan funds are misappropriated by a third party, AFCA may consider the connection between the misappropriation and the financial firm's lending decision. So this was, I was just giving an example of that. This may involve AFCA considering whether the financial firm was or should have been on notice that the funds may be misappropriated. AFCA will consider all of the circumstances to determine whether it is fair for the financial firm or the complainant to bear the loss caused by the misappropriation. So, is AFCA's approach to loss calculation the lawful approach? Well, I've already opined that it is not, and it's important, I think, to elaborate on that because it's a pretty significant criticism to make about AFCA's approach. We have long advocated for a but-for approach to losses. That is, but for the breach, which resulted in the funds being lent, which should not have been lent. A property was purchased, and that resulted in a capital loss, and hence the wrongdoer, the lender, or the intermediary who affected the breach and caused those losses to be suffered should be held responsible for compensating them. It's a pretty simple proposition. We say it's supported by Section 178 of the NCCP, which allows for the payment of compensation of loss, which we've already been through. We also say it's supported by the common law, where courts have interpreted similar provisions in other acts to mean that the loss or damage which is caused by a contravening conduct can be recovered, and that the contravention of an act only needs to be a cause of the loss or damage sustained, not the sole cause of the loss or damage. So obviously another cause of the loss and damage is the investment decision to buy that particular property, which is not usually the bank's decision. That would be the borrower's, the consumer's decision. But as long as the contravention is a cause of the loss or damage, according to these authorities, compensation is payable by the lender. And I've cited those authorities at the bottom of the slide. So let's talk a little bit more about benchmarking tools. These are used to assess affordability in around 80% of loans, and the HEM benchmark is the one which is most prevalently used over the last decade or so. It's really important to note what the HEM, when the HEM pigeonholes people by taking their demographics and saying what their benchmark expenses are, which is obviously one side of the equation in determining whether a loan can be serviced. The HEM does not factor in all of these highly relevant, I would suggest, household expenses, rent and lease payments, mortgage payments, home purchase costs, HECS and help payments, school fees. I mean, that's a big one. Our list goes on. So that is an obvious flaw in the adequacy of the HEM benchmarking tool. What did Commissioner Hayne in the Royal Commission say about HEM? HEM should not and cannot be used as a substitute for inquiries or verification, notwithstanding that it may have some utility in assessing whether or not a particular consumer is likely to experience substantial hardship as a result of meeting their obligations to repay a line of credit. So it may be a useful tool in terms of validating a consumer's stated expenses, but it would not be a substitute in and of itself for inquiries or verification. That's how I interpret that comment, which I think I agree with completely. Nevertheless, Commissioner Hayne recommended that the NCCP Act should not be amended to alter the obligation to assess unsuitability. Okay, so Commissioner Hayne could have banned the use of benchmarking tools or given some greater guidance as to its limitations and recommended legislation or regulations to apply that greater degree of guidance rather than essentially letting the lenders decide for themselves. He chose not to do that. I think one of the main reasons why Commissioner Hayne took that approach is because he was mindful of the case that was running at the time by ASIC against Westpac, which was seeking to have the court make a finding that its use of the HEM benchmarking tool was unlawful in a number of instances. Commissioner Haynes said, if the court processes were to reveal some deficiency in the law's requirements to make reasonable inquiries about and verify a consumer's financial situation, amending legislation to fill that gap should be enacted as soon as reasonably practicable. So I read that as saying, if this ASIC and Westpac case doesn't clarify the law and it reveals a deficiency in HEM and the use of benchmarking tools, then the legislature should step in. So then we got the judgment after the Royal Commission ended and this recommendation was handed down. We did get the judgment, and it was extremely disappointing for consumers. The federal court dismissed ASIC's responsible lending case against Westpac and ordered the regulator pay the bank's costs. And the finding was that the lender has no obligation to use declared expenses to assess affordability, as they are an unreliable indicia for financial hardship. So where a consumer provides their own expenses on a line-by-line basis, the lender has no obligation to prefer that and to use that in preference to the benchmarking tools. And this is the famous quote from that case from Justice Perham. I may eat Wagyu beef every day washed down with the finest Shiraz, but if I really want my new home, I can make do on a much more modest fare. So the suggestion is there that that the benchmarking tools may actually be more reliable than stated expenses, because people may over-declare their expenses, or their expenses may be too high, even though they could reduce them by tightening their belt. I have trouble with that logic, with all due respect to His Honour, and my experience with consumers who have been given unaffordable loans in particular, where their actual expenses hasn't been properly verified, is that they are not, it's not a question of cutting back on Wagyu beef and fine Shiraz. It's actually a situation where they're down to the bone and are facing foreclosure on their mortgage. But what do I know? The full Federal Court of Appeal agreed with that, upheld that judgment, and so the use of HEM stands. And despite that, in my opinion, revealing a deficiency in the law's requirements to make reasonable inquiries about a consumer's financial situation, the laws have not been amended to fill the gap. So when you're considering public policy lobbying areas of interest, this one I think is fertile territory. Next, broker remuneration. Again, this comes back to the issue of commissions. I've expressed my deep concerns about the use of commissions, particularly for brokers, as did many people during the Royal Commission. And Commissioner Hayne listened to that and made a recommendation accordingly, that the borrower, not the lender, should pay the mortgage broker a fee for acting in connection with home lending. Of course, this is a major threat to the mortgage broking industry, because if they charge borrowers up front for their services, much fewer people will use their services. Of course, borrowers ultimately pay for their services themselves, because the banks who are paying these commissions pass them on to the consumers, which, you know, that must inevitably be the case. Otherwise, banks wouldn't agree to pay these commissions. Nevertheless, the mortgage broking industry was up in arms. It threatened the livelihood of lots of franchise mortgage brokers. They're well-organised industry. They descended on Canberra shortly after this, and the government's initial response, this was the Morrison government, was that from 1 July 2020, the government will prohibit the new loans, for new loans, the payment of trail commissions from lenders to mortgage brokers and aggregators. But then what's actually happened is that the mortgage broker best interest duty and remuneration, in relation to mortgage broker best interest duties and remuneration reforms, these do introduce the best interest duty as per recommendation 1.2, but they do not ban commissions. Okay, so there's no hard ban on commissions, which is what Commissioner Hayne recommended. What they do is cap the commissions at a percentage of the amount drawn down on the loan rather than the loan amount. And it was said that that would be reviewed in 3 years. I'll have to check up and see where that's up to, but I haven't heard anything. So we still have commissions paid to mortgage brokers. Okay, with a little bit of time we have left, I'm just going to run through a case study which I think highlights this difference in approach between AFCA and the courts. Although we didn't end up getting a court judgment, the matter settled. Because the matter settled, I have had to de-identify this case study, but I think it is still useful for illustrative purposes. So the borrower, who we're going to refer to as W, at the time of the loan was an Indigenous woman in her mid-40s, blue-collar worker. She owned her own home, a residential property, with liability of approximately $250,000. So she had substantial equity in her home, but she still had a substantial mortgage. Wanted to invest in property to assist with retirement income and build wealth, like so many Australians. Had no prior investment experience aside from holding a superannuation account. So the loan was entered into to build a new property in central Queensland. This was during the mining boom. We're going to refer to this as the investment property, IP. When entering into that IP loan, the lender estimated the value of the investment property upon completion would be $480,000. And so this meant that the loan was actually 120% loan to value ratio, which is too high. That's at an unlawful and unsustainable level of LVR. The loan was $575,000 for the purchase and construction of the investment property and the usual incidentals. So this is where this issue about requirements and objectives comes into it. The lender should have been looking at what are the requirements and objectives and doing the math and seeing that this was actually an unviable investment, even during the mining boom. The loan was cross-secured against W's home. Following the construction, the investment property value estimated at just $400,000, which put the loan to value ratio at 143%. It was tenanted on a fairly regular basis, but had difficulty maintaining repayments due to decreasing value and the end of the mining boom in central Queensland, so when rents went down substantially. And by 2021, the investment property estimated value was $320,000 only. So we've got a serious problem here. A complaint was made to AFCA. It was lodged by the woman who became our client, W. It was lodged against the lender for breaches of the NCCP on the basis it was not affordable and not suitable. The lender offered to settle for $90,000, so to write down the loan by $90,000, but that wasn't enough to clear either loan, so they would both remain on foot. AFCA found in W's favour, found in relation to breach, but also in relation to calculating losses. They were calculated at $120,000 only, and that comprised of the interest paid and some incidentals. So they applied their methodology, which we discussed before, which doesn't factor in capital losses. No losses awarded for significant capital loss that would be incurred if the investment property was sold, as AFCA were of the view that the choice to purchase the property was one property over another was the decision of the borrower, not the lender, and the lender cannot therefore be held responsible for the investment decisions of the borrower. So this is the approach that we've already discussed. So we took on the case because of these substantial capital losses. We thought that AFCA's reasoning in relation to its loss assessment was wrong, and we sued the bank through the federal court by way of a concise statement, and we claimed the usual heads of loss plus capital losses, which would be incurred if the property was sold. Importantly, we rejected AFCA's determination so that we weren't bound by it. The capital loss head of damage was sought under Section 178 of the NCCP, pursuant to interpretation of similar provisions in other acts, and we've already discussed 178 and the principles that we apply here. And during the litigation, the investment property was sold because there was it was just unsustainable, and the capital loss was realised, and that actually placed the family home at risk of recovery by the lender due to the cross security. So it was dire straits there. The litigation matter did resolve at a mediation, or shortly following a mediation, and that resolved on the basis that W could retain her residential property and owe no further funds with respect to the investment property. So the investment property loans were written off by the lender in full. Okay, and by progressing through litigation in that way, compared to AFCA, she did better to the tune of $200,000. So I suppose it goes to show that not only can this argument be advanced through AFCA for capital losses, but the banks take that argument seriously. They see that they have exposure in relation to it, and I think that this is fertile ground for litigation. This was taken on as, I suppose, a test case. If we can get to the point where we can actually have the legislation amended, if we can get to the point where we actually get a decision from a court on this point, we can then waive that in front of AFCA to challenge its loss assessment methodology. We haven't gotten to that point yet. And so despite all of the public policy submissions and lobbying that I've done to try to raise awareness of this issue with AFCA, they've remained steadfast in their approach. So litigation is the only option really on the table in those instances. And so for what it's worth, my firm has developed a bit of a practice of taking on these sorts of cases because the losses can be very substantial. Mind you, the bank was very, very clear that it would not be paying a cent towards legal costs because presumably it doesn't want to support a plaintiff law firm business model on this issue. And so for that reason, we largely did this case on a pro bono basis with the exception of some disbursements. Okay, so just one very brief final thought about the Bankruptcy Act. This is a problem because under Section 116 of the Bankruptcy Act, a legal cause of action vests in the trustee in bankruptcy. So I've got there it vests in the creditors. That's not technically right, as those on the call would know. It vests in the trustee in bankruptcy who has to have due regard to the creditor's interests. Okay, and so what that means is that if somebody becomes a bankrupt, perhaps it's because of the financial hardship they find themselves in due to irresponsible lending, they don't actually own their own cause of action to bring that irresponsible lending claim. Now, AFCA will usually still let them bring it, but if they were to go to the court, the proper plaintiff would need to be the trustee in bankruptcy or somebody who the trustee in bankruptcy has assigned that cause of action to. That's obviously a serious problem because it means the ability for a consumer to pursue their legal rights against a irresponsible lender who may have caused them to become bankrupt cannot be pursued because most of the time, in my experience, a trustee in bankruptcy has no risk appetite for litigation of this type. Some years ago, I made submissions to the Legal and Constitutional Affairs References Committee on resolution of disputes with financial services providers within the justice system. That was a mouthful, the name of that recommendation, my gosh, the name of that committee. And a recommendation was made that the Bankruptcy Act should be amended to prevent causes of action relating to consumer credit protections from vesting in the trustee in bankruptcy. Despite that recommendation, no such reforms have been enacted. So again, if you're looking for areas to pursue in terms of public policy, I think this is an important one. It's one that I continue to pursue. So that's the end of the slide pack. We've got a couple of minutes for questions if we have any.
Thanks so much, Josh. Excellent presentation. I think that the case study you presented really illustrated the situation very well. Great that you were able to get a good outcome for that client. So there have been a few questions and comments coming through, so I might just do them in order. So sort of cast your mind back to mid-presentation. Question from Matthew, or sort of a bit of a comment question. So arguably then would the 6-year limitation period restart every time interest is charged monthly because that is a loss? And I think that was in relation to the AFCA time limits slide around complaints to which the National Credit Code applies.
Yeah, it's an interesting question. I think it hasn't been tested. I understand the argument that because these losses are rolling losses or ongoing losses, and so it would be those losses which are still within the 6 years which could still be claimed. I think I agree with that in principle, although a defendant might make a Wardley type argument, even though Wardley relates to negligence, they might make a Wardley type argument to say, well, it was reasonably knowable or ascertainable that those losses would be incurred from an earlier point in time. So you need to be a bit careful about assuming that later interest repayments would still be recoverable.
Great, thank you. Jeanette has asked, and I'm not sure whether you subsequently covered this, Josh, but has the contradictory treatment of gains and losses by AFCA been tested in court?
No. No, we tried, and the bank, I think this particular bank at least, must have received legal advice that they had some exposure on this point, or else they wouldn't have offered an outcome that was $200,000 better than that which we could have taken in AFCA. So the banks clearly don't want a precedent set on this point, which is all the more reason to bring appropriate test cases.
And Matthew has also asked, is it possible that AFCA's position that crystallised investment losses aren't to be awarded as compensation may change now that they have recently released their new approach to responsible lending documents?
Well, I looked at the most recently published approach document, and that was what I'd put on the screen. So if there's been one since that I've missed, then I'd need to go and have a look at that. But I haven't heard any word that they've changed their approach.
Okay. And you mentioned obviously legal fees not covered by the bank in the case study, but Matthew is also wondering whether W still got all her losses refunded, such as interest fees and charges.
Yes. Yeah. So it was pretty much the claim was pretty much paid in full. It was as good an outcome as could have been achieved at trial, except that if we had won at trial, we would have gotten a costs order. So that was a trade-off for having a resolution without having to put the plaintiff through the stress. And also, of course, you know, whilst pursuing litigation of this type, it's not just the stress of the litigation, it's the fact that the loan is still sitting there as an imposition. And you know, that is enormously stressful, and that is a huge advantage that the defendant has in these types of litigations. So the client opted for a resolution, and we didn't stand in the way on the basis of wanting to be paid. So it was just one of these situations where we brought a test case, and it paid off for the plaintiff, and I think it's a really powerful one to share, and it's one that, as I said, ultimately we did largely pro bono.
Yeah, fantastic. So a bit of a comment from Emily. It's a long one, so I'm going to just read it out. So thanks, Josh. Down here in Victoria, we have the Victorian Home Buyers Fund, which allows for essentially higher purchase price entry first home buyers, where the Vic government can have up to 25% equity in the property. The Victorian government's contribution will need to be bought out after a certain income level is reached, which would likely then be added to the pre-existing mortgage. Have you considered the obligations of lenders when considering credit alongside schemes like this?
No. Yeah, it throws a spanner in the works. It's a little bit. It sounds a little bit like the government's early access to super type reforms and further proposed reforms by the opposition. Yeah, the extent to which those government funded payments can and should be taken into account in the LVR equation, I think is a really interesting question. I think there's room for problems to emerge if they are taken into account there in full. But I'd need to have a look at that specific piece of legislation and probably an associated case study. Happy to discuss that further offline.
Great. And I might take this one as the final question for today's session, just being mindful of the time. So Trish has asked, with the time limit for complaints to AFCA, does 2 years from the date the credit contract is rescinded, discharged or otherwise comes to an end, mean from the date of variation of the credit contract due to financial hardship?
Variation, yeah, well, I think that's right, because it's variation. So I think you'd want to be on the right side. You'd want to be pretty circumspect about that, and I think you probably would want to assume that it's from the date of a financial hardship, of a hardship variation.
Excellent.
It's a change to the credit contract. Yeah, good question. Yeah.
Yeah. Great. So a few comments just coming through. Also, a very helpful presentation, very valuable. I'm so glad you mentioned profits. Not enough people recognise how this has influenced costs of living rises. So lots of excellent positive comments coming in there, Josh. So I think that's a really nice time to bring today's session to a close. Always a pleasure to have you present, Josh, and thank you everyone in the audience for your great questions and engagement through the session. So I might just remind everyone to complete the short feedback survey that will come up automatically on the screen once you shut the presentation down. And that feedback is really helpful to us to hear what you're interested in and any ways that we can improve our program of webinars. So once again, on behalf of everyone here today, thank you very much to Josh and Maurice Blackburn and your continued support of the community legal sector. We look forward to seeing you at our next webinar session, and hope you all have a great rest of your day. Thanks again, and bye for now.
Thanks all, bye.